Many injury cases settle without the need to file a lawsuit or ever go to court. But many times, the insurance companies and corporate defendants of the world fail to make a fair and reasonable offer prior to an injury victim filing a lawsuit. In this video, I'll discuss when it makes sense to file a lawsuit in your injury case. To start things off, let me tell you the story of Sandy. A short time ago, Sandy contacted me and asked me to represent her for her car accident injury claim. Liability in Sandy's case was not at issue, as the driver who caused the accident was clearly at fault, and the at-fault driver's insurance company never disputed liability. However, Sandy had a history of issues with her neck and back prior to her motor vehicle accident. She told me her car accident worsened her condition, causing significant aggravation to her neck and low back. Sandy did not seek immediate medical attention after her car accident. A couple days after her accident, she called into her previous doctor's office that she had been treating with to report that she had been in an accident and to schedule an appointment. She was never seen by any medical provider until 2 months after her accident. At that time, her medical records reflected that she complained of pain that was worsening. She was next seen almost 5 months after her accident, at which time she again complained that her pain was worsening. During this time, Sandy had been handling her injury claim on her own. She had gotten nowhere by the time she called me. The insurance company had not offered her a penny and was being difficult with her. When Sandy called me, she was lost as to what to do next. She was in bad shape and needed surgery on her neck. She had a first surgery on her neck after 8 months following her accident. A second surgery was needed just a few days later. After I obtained her medical records from her surgeries, I sent a written demand to the at-fault driver's insurance company demanding that they pay out their insured driver's insurance policy limits. In response to my written demand, the insurance company only offered to settle the case for $5,000, arguing that the first time Sandy had reported cervical pain after the accident was at her doctor visit 5 months after the accident, and that in those records, it notes that her pain began 4 to 5 years ago, that her pain was worsening, but the records from that visit did not mention the motor vehicle accident. Side note, this is an important lesson. Insurance companies heavily rely on medical records when adjusting injury claims. It's a good idea to remind your medical providers every time you visit after a car accident that you had been in a car accident which caused your pain, and they hope that the medical provider puts it in their medical records. If it winds up in your medical records that you've been involved in an accident, it will make it easier sailing with the insurance company for your injury claim. Now back to Sandy's story. Sandy and I were not happy with the $5,000 offer. I thus recommended she see an independent doctor for an independent medical exam. She did, and the doctor linked the need for her surgeries to her auto accident. I sent this doctor's report to the insurance company and again demanded that the insurance company for the at-fault driver pay out the policy limits. The insurance company again argued that Sandy's medical condition was pre-existing and that her medical treatment, including her surgeries, were not related to the automobile accident. They then only offered $7,500 in the spirit of coming to a compromise and settling her case according to the insurance adjuster. In response, I then immediately filed a lawsuit. After litigating the case for a short period of time, I was finally able to get the insurance company to come to their senses. They finally offered their 6-figure policy limits and the case settled. So what's the lesson here? Clearly in Sandy's case, it was worth filing the lawsuit. Her damages were significant as she had 2 surgeries and the insurance company had only offered us $7,500 to settle her case prior to us filing the lawsuit. You see, by filing a lawsuit, an insurance company or corporate defendant knows that they will not only have to pay a defense attorney by the hour to defend the lawsuit, but they will also rack up case expenses to defend the lawsuit. Their defense attorney will need to take depositions, and they may even eventually have to hire an expert. After a lawsuit is filed, it can get costly for the insurance company, and it's something the insurance company will consider when evaluating your claim. Filing a lawsuit also puts pressure on the insurance company to make you a fair and reasonable offer in your case. You see, if you end up getting a verdict in excess of the insurance company's insured's policy limits, or a verdict larger than the last offer prior prior to trial, the insurance company can possibly be sued for acting in bad faith, an entirely separate claim they will have to defend and possibly pay out on. By filing a lawsuit, the insurance company or large corporate defendant will also take your claim more seriously. It will make them realize you are someone that won't back down and that you are serious about getting a fair and reasonable settlement offer on your case. At the end of the day, what you ultimately have to tell yourself before filing a lawsuit is whether it is worth the risk to file a lawsuit for a possible big payday in light of the last offer made to you prior to filing your lawsuit. Keep in mind, filing a lawsuit usually delays getting you paid on your case. After filing a lawsuit, you may even have to be more actively involved in the case by answering written discovery questions, attending your deposition, mediation, and other events that come up along the way. If the offer to you is fair and reasonable prior to filing the lawsuit, you need to consider accepting that offer. But if you think you can make out better and are willing to fight in court for a payday that is worth the risk for you, go ahead and file a lawsuit. The thing is, how do you even know if the last, best, and final offer made to you prior to filing a lawsuit is a fair offer? Well, in order to know that, you must be able to calculate your damages sustained in your injury claim. And in this video about to pop up here, I'll provide you with the tactics used by insurance companies and injury lawyers to calculate damages sustained in an injury claim. Lastly, if you've been injured in an accident in Kentucky, remember to don't wait, call Tate.